In this video, we will continue our examination of the parties' rights and remedies where the buyer rejects the seller's non-conforming tender of goods by focusing in on the seller's limited right to cure any non-conformity. We are now assuming the buyer had the right to reject the seller's tender, stated differently, that the buyer's rejection was rightful, and we are further assuming that the buyer took the proper steps to make an effective rejection, something that we covered in the last video. So what happens next? Well, in some instances, the seller may have an opportunity to cure the nonconformity. That is, the seller will have the right, but not the obligation, to salvage the deal by correcting or ameliorating its breach. The seller's right to cure may be something that is addressed by the parties' agreement. For example, the parties' agreement may expressly specify that there is no right to cure, or the parties' agreement may expressly specify that the seller can cure and give a timeline for any such cure. Press pause now to carefully read these two example contract excerpts to see what such contractual language might look like. In the absence of the parties' agreement on the seller's right to cure, Section 508 of Article 2 operates as a gap filler, a default rule. 508 articulates two situations where the seller has a legal right to cure. Let's start with subsection 1 first. Subsection 1 says that where the seller's tender of goods is rejected because the tender is non-conforming, but the time specified by the parties' contract for the seller's performance, that is the deadline by which the seller was contractually obligated to make a conforming tender, has not yet expired, then the seller may cure by making a conforming tender within the contractual deadline. This subsection is relatively straightforward. Imagine the parties' contract requires the seller to deliver 1,000 pounds of dark roast coffee beans to the seller by Friday. The seller instead delivers 1,000 pounds of light roast beans on Thursday. The buyer rejects these light roast beans because they are non-conforming. Then the seller still has until Friday to cure by tendering conforming dark roast beans. Under 508 subsection 1, the seller will have the legal right to cure. Subsection 1 is relatively easy to understand. Subsection 2 is much more nuanced and inscrutable. It applies only where the seller reasonably believed her tender was conforming. That is, either through her negligence or innocent oversight, the seller did not know or expect that her tender of goods would be rejected by the buyer. But the goods or the manner of the seller's tender is in fact non-conforming and the buyer does reject the seller's tender. Then the seller is allowed a further reasonable time to cure with a conforming tender. So the seller is allowed a further reasonable time beyond the contractual deadline for when the seller's tender was due to furnish a conforming tender, even though that tender is technically late under the party's contract. The policy reflected in this rule is one that aims to protect a good faith seller from a surprise rejection, while balancing that aim against the expectation interests of the buyer who had contracted to receive conforming goods. So, what is a further reasonable time? Comment 3 to 508 provides just a tiny bit of guidance. It says that a further reasonable time is language intended to protect the buyer. So, what is a further reasonable time depends entirely on the buyer's needs for the goods, not what is reasonable from the seller's perspective. If the buyer's needs for the goods has passed, then perhaps no additional time would be a reasonable time. But if late delivery of conforming goods would not meaningfully injure the buyer, then the seller is allowed a further reasonable time to cure with a conforming tender. Note, even if seller cures under subsection 2, the seller's failure to make a conforming tender on time within the time frame required by the party's contract is a breach of that contract. So the buyer may be entitled to damages for the seller's breach. But what the buyer cannot do is reject the seller's cure, to reject the seller's conforming tender. Instead, the buyer must accept the seller's cure and seek damages, or more likely a concession on price from the seller for the late but otherwise conforming tender of goods. What qualifies as a cure? Well, who knows? This is another point on which the UCC is completely silent. Presumably, it would be any action by the seller that negates or corrects its initial breach. Where the seller's goods are non-conforming, the answer seems easy enough. The seller can cure by simply fixing or replacing the non-conforming goods with conforming goods. But what about where the goods are tendered late by the seller? That's the kind of nonconformity that cannot be cured. The seller cannot go back in time and make a tardy tender timely. Try to say that 3 times. But the seller may give the buyer a concession on the price to be paid to the seller to compensate for the seller's delay. Perhaps a concession on price for the seller's untimely delivery could be characterized as a cure, but more accurately, it is really just a settlement of the buyer's claim against the seller for breach. So in this video, we outline the situations where the seller has a legal right to cure upon the buyer's rejection of the seller's non-conforming tender. And we also noted the limited nature of that right. In the next video, we will conclude this week's module by considering the measure of buyer's damages upon its rightful and effective rejection of the seller's nonconforming tender.